Welcome, and thank you for joining us. Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, if you find this content valuable, we kindly request you to like the video, subscribe to the channel, and activate the notification bell to receive updates on future episodes. Let's begin.
Okay, imagine this. You've invented something truly brilliant, poured your heart into it, filed the patent, and then boom, you find out it might be invalidated. And the culprit, a YouTube video.
Yeah, it sounds almost unbelievable, right? But it's a real issue.
Exactly.
Yeah.
It seems wild. So let's unpack this. Our mission today is to take a deep dive into how user-generated video content, stuff on YouTube, is really changing the game for patent law. We'll be looking at the U.S. and India specifically, drawing on statutes, some key cases, the Indian Patent Acts, and commentary from experts.
And it's fascinating because the rise of digital media, it's just completely challenged the traditional ideas about prior art.
Right.
That's the legal term for anything public that could block or kill a later patent. We're going to explore the really critical differences in how the U.S. and India actually interpret this stuff, especially for videos.
Yeah.
Which brings up a big question, really. In this world of instant sharing, what actually counts as public?
That is the core question, isn't it? We've mentioned prior art, but let's drill down. How do the U.S. and India define it, particularly for something maybe less traditional, like a video?
Okay, so in the U.S., the law, 35 U.S.C. Section 1 or 2, it defines prior art pretty broadly. It includes printed publications.
Printed publications? But we're talking video.
Exactly. And what's interesting is how broadly the USPTO, that's the Patent Office, interprets printed. Their manual, the MPP, explicitly says it includes electronic publications. And yes, that includes digital videos.
Ah, okay.
The key condition, though, is public accessibility. It needs to have been disseminated or otherwise made available so someone in that field, using reasonable effort, could actually find it.
Like finding a book in a library. I think I read that comparison somewhere. Needs to be indexed, searchable.
That's the analogy courts sometimes use, yeah. It implies a level of organization or findability.
Okay, so the U.S. sort of stretches printed to cover findable online stuff. But India, you mentioned, is different.
Totally different approach. Indian law, the Patents Act of 1970, works on an absolute novelty standard.
It's all with novelty.
Right. An invention is only new if it wasn't anticipated by publication in any document or used anywhere before the filing date. There's no separate category for printed publications.
So no wiggle room based on how it was published.
Pretty much. Any public disclosure in any document by any means anywhere in the world that can destroy novelty. The Indian Patent Office Manual defines prior art very broadly. Everything that has been published, presented, or otherwise disclosed to the public before filing.
Wow. Okay, so the U.S. is more focused on, like, discoverability. Was it indexed, searchable, findable? And India just asks straight up, was it out there? Publicly disclosed, period.
That's a good way to put it. The U.S. is about accessibility. India is about the sheer fact of prior public disclosure.
Which, naturally, leads to the next big question. How do you actually prove it? How do you prove a video was public and when it was public? What kind of evidence are we talking about?
Yeah, the evidence part is crucial. In the U.S., especially in these post-grant challenges, like IPRs.
Inter partes reviews, right?
Exactly. The bar for video evidence is quite high. The petitioner, the challenger, has to show not just what was in the video, but crucially, when and how it was publicly accessible.
So what does that mean in practice? Like, what do they need to show?
Concrete stuff. Screen captures showing the YouTube URL, the upload date, full transcripts, sometimes archived copies, from the Internet Archive's Wayback Machine.
Wayback Machine.
And even sworn affidavits. Statements from the person who uploaded it or maybe someone who watched it back then.
Okay. Are there cases that show this?
Definitely. Think about Echo Brands v. Think products. The challenger won there because they showed a product video was just sitting on a public website for a whole year. They had screenshots, witness testimony, the works. But then you have cases like Medtronic v. Barry. There, a video on a conference CD-ROM was found not to be adequately disseminated. It wasn't accessible enough. So it really hammers home that point. Dissemination accessibility, those are key in the U.S.
Okay, that makes sense for the U.S. system's focus. Now, does India have these same kinds of strict rules for evidence when it comes to digital stuff like videos?
Not quite the same. India doesn't really have a separate set of rules just for different types of media. A video is generally treated like any other document.
Simpler in a way.
Maybe. To invalidate a patent, the challenger still has to prove the video's content and the date it was disclosed. Often that means downloaded transcripts, maybe certified screenshots. Now, the patent offices themselves aren't super bound by all the strict rules of the Indian Evidence Act.
Okay.
But if it goes to court, then yes, electronic records usually need a certificate under Section 65B to be admissible.
So there's still a formal process for court.
Oh, absolutely. The burden is still squarely on the challenger. They have to authenticate the source, prove it's publicly available before that critical date.
Got it. Let's talk about some aha moments from the courts. How does this play out in real cases? You mentioned the U.S. seems to have more case law specifically on this.
Yeah, the U.S. definitely has a clearer line of decisions here. There's a case, HVLPO2 LLC v. Oxygen Frog. A district court flat out said a public YouTube demo video was prior art.
Just like that.
Pretty much. They noted users could find it with a normal keyword search. And the judge even made this comment, something like, it appears that plaintiff is unfamiliar with how YouTube works.
Huh. Okay, point taken. Searchable means public.
Exactly. It really shows how courts view digital accessibility now. And there's another case, Blue Calypso v. Groupon. It wasn't about video, but a PDF. It was on some obscure, unindexed website. The court said that wasn't publicly accessible. And they specifically contrasted that situation with platforms like YouTube, where things are typically searchable, indexed, show upload dates. Get the picture.
Yeah, I do. So U.S. courts seem pretty comfortable saying findable YouTube video. That counts. What about India? Have they had similar big cases involving YouTube specifically?
That's where it gets really interesting. As far as reported decisions go, there aren't really any major Indian patent cases that turn solely on a YouTube video invalidating a patent.
Why do you think that is? The law seems clear enough, the absolute novelty standard.
It could be a few things. Maybe practical challenges in authenticating that kind of dynamic digital evidence to the standard required in Indian courts. Or maybe parties just tend to rely on more traditional, easier-to-prove documents when they can.
So the law might allow it, but maybe the practice or the evidence gathering is still catching up.
That could be part of it. It suggests a legal system that's still sort of evolving its practical approach to digital prior art, even if the underlying legal principle is clear. In theory, an Indian examiner or court should accept a public video if the content and date are proven, and the IPO manual's broad definition certainly supports that.
Okay, so summing this all up, what does this mean for people listening? You know, if you're an inventor or a company trying to manage your IP, or maybe someone looking to challenge a patent.
Right, the practical takeaways. For applicants and inventors in both the U.S. and India, the message is crystal clear. Be really careful about public disclosures before you file your patent. That absolutely includes posting videos on YouTube or social media.
Don't show off the secret sauce too early.
Exactly. If you do disclose something, file that patent application pronto. Now, the U.S. does give you a 1-year grace period for certain disclosures you make yourself.
A bit of breathing room.
A bit, yes. But India's grace provisions are much, much narrower. So that informal demo video you posted, even if it feels casual, it could absolutely come back to bite you. It's like forgetting to lock the door before the patent examiner walks by.
Good analogy.
Yeah.
Okay, what about the other side? If you want to use a YouTube video to challenge someone else's patent.
For challengers or opponents, it all comes down to documentation. Really robust documentation. In the U.S., like we said, you need solid proof of accessibility. Was it findable?
Right.
So detailed screenshots, URLs, dates are vital. Archive captures from Wayback Machine, maybe even those sworn statements from witnesses. In India, you need to prove the fact of the disclosure and its date. Certified transcripts, dated screenshots that will hold up under scrutiny. Your job is to convince the examiner or the court that this video was genuinely out there in the public domain before that critical filing date.
It sounds like a lot hinges on proving not just what was shown, but when and how it was accessible. And given how fast digital content moves, how things appear, disappear, how do you see these rules evolving? Content is getting even more, ephemeral.
That's the million-dollar question, isn't it? How does patent law keep up with the speed and nature of online content? It's a constant challenge.
So let's wrap up this deep dive. We've seen how a simple YouTube video, something we might scroll past every day, can actually hold huge power in the patent world. Both the US and India do recognize that widely shared videos can be prior art.
They do. But the key difference is really in the approach and the proof needed. U.S. law zeroes in on public accessibility. Could someone skilled in the art actually find it? And that requires pretty detailed proof about searchability, indexing, dissemination.
While
India, with its absolute novelty standard, theoretically just asks, was it publicly disclosed at all, anywhere, anyhow? But as we discussed, there might still be practical hurdles in proving that digital disclosure convincingly.
So the bottom line, really, for anyone touching intellectual properties, you've got to be meticulous about documentation, and you need to understand these different, sometimes subtle evidence requirements.
Yeah.
And maybe for you, the listener, the next time you're just casually scrolling through YouTube or TikTok or whatever comes next, just pause and think. Could this seemingly informal share, this public post, actually have some really profound legal consequences down the road?
It's definitely something to think about. It truly is a brave new world for IP.